Well, I'd like to welcome everybody this afternoon to our briefing on Christian Legal Society versus Martinez, which is going to be argued before the United States Supreme Court on Monday, April 19th. And I think it's really a testament to the importance of this case and the illustrious pedigree of our panel that you have all turned out on this beautiful spring, or maybe we'll call it early summer day in D.C. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. For those of you who may be unfamiliar with ACS, we are a national network of lawyers, law students, scholars, policymakers, and judges that promotes the vitality of the Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. Christian Legal Society versus Martinez raises very interesting legal questions that really hit right at the heart of our democracy. These issues are at the intersection of anti-discrimination laws and policies and a variety of First Amendment principles: freedom of speech, freedom of association, and freedom of religion. The interplay between these areas of law is complicated and has led different courts to reach different results in similar cases. How these principles can coexist in our public colleges and universities is of critical importance. Given the importance and complexity of these issues, we are delighted today to have an outstanding panel of experts. The details of their impressive accomplishments are in the handout that you should have received at the door. Each panelist participated in the filing of an amicus brief in this case, so we could not have a better group to explain what's at issue, as well as arguments that will likely be made during oral argument 10 days from now. Our moderator will briefly introduce each of the panelists, but it is my pleasure to introduce our moderator, Professor Melissa Rogers. Melissa, who is co-chair of ACS's First Amendment Issue Group, is director of the Wake Forest Divinity School's Center for Religion and Public Affairs and is a non-resident senior fellow in the governance program of the Brookings Institution. She is a leading expert on church-state issues and the interplay between religion and public policy. Melissa's expertise has been recognized by no less an authority than President Barack Obama, who appointed her to his advisory council on faith-based and neighborhood partnerships. She has also held many other important positions during her career, including serving as the executive director of the Pew Forum on Religion and Public Life and the general counsel of the Baptist Joint Committee on Religious Liberty. We could not have a better person to lead our conversation today. So now I will turn it over to Melissa.
Thank you, Caroline. Oh, thank you. Thank you so much, Caroline, for that very kind introduction. And I want to thank you for the work that you are doing, and especially your leadership at the helm of ACS. We are very grateful for your leadership and the dynamism and the vitality of the programs across the swath of ACS's issue areas, as well as the organization itself. I want to thank Tom Sharp as well for organizing and sponsoring this activity. And I also want to recognize the other co-chairs of the First Amendment section of ACS, Bill Marshall, a visiting professor this year at George Washington University Law School, and Cliff Sloan, who will be participating on the panel, and I'll introduce him in a moment. They, with Tom Sharp, we all worked together to put together the panel, and we're grateful that we're able to have such an outstanding panel with us this morning. I want to introduce each of our panelists, but before I do, I'm just going to offer a very brief sketch of the factual and procedural background for the case and just touch on a couple of the issues that are at stake to set the stage for our discussion. The University of California Hastings College of Law is a public law school in San Francisco that allows students to create what are called registered student organizations, or what we'll call RSOs from now on. During recent academic years, there have been about 60 RSOs, and they have covered a wide variety of areas of interest, including not only politics, culture, race, and religion, but also environment, sports, and recreation. RSOs are entitled to meet in university rooms and apply for what Hastings calls modest public funding to support their activities and to utilize various forms of communication on the campus, including things like mass emails to the student body. Hastings requires these student groups to abide by certain ground rules. The groups have to be non-commercial and their membership must be limited to Hastings students. There also is a Hastings non-discrimination policy. About that much, the parties agree, but once we start getting a little bit past that, we see that the parties have some differences. I'll say more about that in a moment. This case began when the Hastings Christian Legal Society, which I'll call CLS, sought permission to form an RSO. Hastings refused, saying CLS's bylaws were not compliant with the applicable non-discrimination policy, and it refused to provide an exemption for CLS from those policies. CLS welcomes all Hastings students to participate in its activities and its meetings, but in order to be a voting member or an officer in the group, students are required to affirm the organization's core beliefs by signing a statement of faith and seeking to live their lives by that statement. According to CLS, this statement requires a profession of the Christian faith and seeking to abstain from acts of what CLS refers to as a sinful nature, including not engaging in what it calls, and I'm quoting here, unrepentant participation in or advocacy of a sexually immoral lifestyle. CLS's understanding of this statement is that it would include any sexual conduct outside the confines of marriage between a man and a woman. Hastings interprets CLS's stance as a violation of its non-discrimination policy. And Hastings points to a long-standing non-discrimination policy it has had that prohibits RSOs, these registered student organizations, from discriminating on the basis of a number of categories, such as race, color, religion, and sexual orientation. It also points to a broader prohibition in that long-standing policy that counsels against legally impermissible, arbitrary, or unreasonable discrimination. And Hastings says it interprets that latter phrase, that broad phrase about non-discrimination that is legally discrimination that is legally impermissible, arbitrary, unreasonable, to prohibit RSOs from discriminating on the basis of status or belief. And this is sometimes referred to as an all-comers policy because it basically says that all groups must accept all students as voting members, even if they disagree with the mission of the group. So, for example, Hastings has said in its briefs that the Hastings Democratic Caucus must accept Republican students as members or leaders in their organization. The Christian Legal Society, however, asserts that this specific protected category policy, the one that prohibits discrimination on the basis of race, religion, and sexual orientation, has been the operative policy here. Indeed, it claims that the all-comers policy was not raised by Hastings until the discovery stage of the litigation, when CLS was pressing Hastings witnesses about whether the protected category policy discriminated on the basis of viewpoint. CLS argues that there are some secular RSOs at the university, including the Black Law Student Association and the Lawyers Guild, that have bylaws that restrict their membership or leadership to students that adhere to a certain set of core beliefs. And so it argues that none of those organizations were prohibited from making those kind of distinctions and requiring that kind of adherence to core beliefs, while CLS was denied RSO status because of that. Nonetheless, and Hastings responds by saying there's no evidence that they did not require all groups to accept all comers, and that the policies that exist in all organizations have been interpreted and implemented to meet the dictates of that policy. CLS argues that all of these non-discrimination policies are constitutionally defective. And when it was denied permission to form as an RSO on the university's campus, it sued, alleging violations of its First Amendment rights to free exercise, free speech, and free association. It claims that the university's denial of recognition to a student group that wishes to participate in a campus speech forum is a form of prior restraint, and is thus presumptively unconstitutional. And it says there's no good justification for the policies that Hastings asserts. And it also argues that the right to associate that is protected by the First Amendment includes the right to control the message and identity of a group by requiring that those who are participating in the group and leading the group, well, I should say just leading the group because that's where their policies kick in, those leaders must share the core beliefs of the groups. Hastings defends its policy as a constitutionally permissible limit on participation in a publicly subsidized university program, a university that is a public university. It says that its non-discrimination policies are viewpoint neutral and non-coercive. No one is forcing anyone to do anything, Hastings says. The groups just need to meet non-discrimination requirements in order to have RSO status and to be able to access rooms in the university on a priority status and to have access to funding. So they say that this is just they're just imposing reasonable conditions on access to this forum at the university. Well, when CLS sued, the district court ruled in favor of Hastings. It denied CLS's motion for summary judgment. It said the policy regulated conduct, not speech, and said the interest in prohibiting discrimination was particularly critical in the context of education. Even if the Hastings policy could be construed as regulating speech directly, the court said it still passed constitutional muster because it was viewpoint neutral, it applied to everyone, and it was reasonable. It also rejected the argument about free association, saying again that lifting up Hastings' argument that no one was being coerced to do anything here. It was just an access to a forum that gave them special rights to access to rooms at the university and access to funds. And so the CLS could continue to meet on campus, the court said, but it couldn't have this special status unless it agreed to the conditions that were asserted. So the lower court ruled in favor of Hastings, and the Court of Appeals affirmed the lower court's ruling, and that's when CLS petitioned the Supreme Court, and they agreed to hear the case. Well, we have this morning again with us some wonderful panelists to shed more light on these arguments, to talk about the various complex facets of this case, and to talk about, of course, what's at stake in this case, because it is a very important case that touches on so many core First Amendment rights that we need to discuss, and also could have implications if the Supreme Court rules in certain ways that go beyond a speech forum at a university campus setting, and might even, the university asserts, have implications for situations in which the government provides subsidies to non-governmental groups, including religious groups, to provide a range of government-funded services, including government-funded social services. So in the mix of all this, we've heard arguments about the oft-debated topic of religious groups making religious decisions about positions that are job positions that are government-funded in government programs. So we'll talk about that as well. Let me give you a brief introduction of all the panelists. Since you have their bios in your materials, I'm not going to do much in terms of introduction, but I do want you to have a few details. First, we will hear from James Bopp, Jr., who is General Counsel to the James Madison Center for Free Speech and a member of the firm of Bopp, Colson, and Bostrom. His extensive Supreme Court practice includes successfully arguing the landmark case Republican Party of Minnesota versus White, which struck down restrictions on the speech of candidates for elected judicial office on First Amendment grounds. Mr. Bopp is also Vice Chairman of the Republican National Committee and a Commissioner of the National Conference of Commissioners of Uniform State Laws. And we're so glad that he can be here. He filed an amicus brief in support of CLS in this case and will be joining us first for a discussion of some of the arguments on that side of the case. Next, we'll hear from Aisha Khan, who is Legal Director of Americans United for Separation of Church and State. She directs a wide range of litigation at Americans United and has been recognized as one of the outstanding litigators in the church-state field. She was lead lawyer in a challenge to Chief Justice Roy Moore's erection of a Ten Commandments monument in a judicial building in Montgomery, Alabama. And prior to coming to Americans United, she was a staff attorney for the ACLU's National Prison Project, where she litigated a number of pieces of complex litigation and class action cases. Prior to that, she was in private practice at Covington and Burling, and she filed a brief on behalf of Americans United and other parties on the side of the Hastings College of Law in this case, and we're glad that she'll be able to go next. Cliff Sloan will then take up another part of the argument that's being asserted on behalf of Hastings College. He filed a brief in this case on behalf of the Lambda Legal Defense Organization. As an experienced litigator, he has litigated at all levels of federal and state courts, including 5 U.S. Supreme Court arguments and numerous arguments at other levels of the U.S. Court of Appeals and in district courts and trial courts across the country. He has served in high-ranking positions in all 3 branches of the federal government, including experience as associate counsel to the president and assistant to the solicitor general. We're very glad that Cliff can join us as well this morning. Holly Holman will round out the panel. She is general counsel of the Baptist Joint Committee on Religious Liberty. She provides legal analysis on church-state issues that arise before Congress, the courts, and administrative agencies. And the Baptist Joint Committee, in this case, filed a brief on behalf of neither party. So we have Holly to join us in that capacity, and she will explain how the BJC reasoned its way through these cases, some of its arguments in support of CLS, and some arguments having concerns that relate specifically to the funding aspect of this case and Establishment Clause considerations. Holly, prior to her work at the Baptist Joint Committee, she was an attorney in private practice specializing in employment law and litigation, and she practiced in firms in Nashville, Tennessee, and in the District of Columbia. So I would ask James Bopp to join us now and to start off our discussion of the case. Thank you.
Thank you, and thank you. Is this on? Yes. Thank you, and thank you very much for the invitation here, and I look forward to a very interesting discussion with the panelists and any questions we might have at the end of this. This is an important case. It involves the application of the First Amendment to public forums, and of course the government often sets up forums for a discussion, for participation, and for speech activities. A bulletin board at a university or a government office could be established as a public forum where the government allows anyone, say employees, to post any notices that they might want to post that they think might be of interest to fellow employees. That would be a public forum. And in the context of a public forum, the court has been very clear that the First Amendment has its fullest application to the public forum, only circumscribed by the purposes of the forum. And of course, I gave you 2 limits regarding the bulletin board. One, it's a public forum open to employees, and secondly, it is for the purpose of employees providing information to fellow employees that they think might be of interest to them. And so the government then cannot come in and say, well, we don't want any messages about Republican Party events or homosexual advocates. We don't want anything from them being placed on this bulletin board because that would be at least viewpoint discrimination. And of course, in a public forum, viewpoint discrimination is death. That is, there is no policy that has survived viewpoint discrimination under First Amendment analysis. So taking that really fairly well-established law, CLS argues that is exactly what we have here, is that we have a public forum established, and that is one that had a specific purpose, and that was, quote, to ensure an ongoing opportunity for the expression of a variety of viewpoints among the students. The forum was open only to students, to student groups and students at the law school and groups that they form. And then they provided them access to a wide variety of first communication opportunities, such as access to the emails of all the students and the right to send out messages to them, special access that all of these 60 groups get to meeting rooms, and also funding to facilitate their activities. So that was what was established at CLS. And the problem that, of course, occurred was the non-discrimination policy of Hastings College. And the non-discrimination policy, the applicable section says, the University of California Hastings College of Law shall not discriminate unlawfully on the basis of race, color, religion, national origin, and ancestry, disability, age, sex, or sexual orientation. This non-discrimination policy covers admissions, access, and treatment in Hastings-sponsored programs and activities. And so while these student groups were not Hastings-sponsored, and Hastings ensured that the students' groups notified everyone that they were not sponsored by the Hastings College. So in other words, these are not government groups. These are not these are not agencies of the law school, and therefore are not the government, because of course Hastings as a state law school is also the government here. But that the public forum that was established for recognition of student groups and access to communication and other resources was a program of the Hastings Center that they did sponsor, and that is the program of student groups. So the problem, that CLS ran into was that this policy had been interpreted to apply to when it said sexual orientation. It applied to homosexual conduct, and the CLS, which is a national organization that has many student groups throughout the country, requires its its affiliates, these student groups, to sign a statement of core beliefs. If you are going to be a voting member or an officer of the group. And among the things that you're required to affirm that you will agree with and conduct yourself in accordance with is no sexual conduct outside of marriage between a man and a woman. And members are required to affirm their belief in that, officers are required not only to affirm their belief, but also to promise to practice in accordance with the beliefs. Now, this is a moral code for this group. It applies to both homosexuals and heterosexuals alike. It applies to any sexual activity except within the confines of marriage. So it would apply to fornication. That's an old term. It used to be in the law. It used to be illegal to do that. Adultery used to be illegal, I think. And of course, homosexual conduct, which became the issue here. Now, they were refused based upon this policy. And if you really examine the policy, it is viewpoint discriminatory. There is only one belief that is barred, and that is discrimination based upon religion. And there is only one behavior that, and this is of course based on the interpretation that Hastings has given the policy, only one behavior that is protected by the policy, and that is as it would be applied here, and that is homosexual conduct. Now, in refusing to recognize the group, the law school said that they must open membership to all students regardless of, one, any their religious belief, and whether or not they adhere to the statement of faith of the Christian Legal Society, and secondly, regardless of their sexual orientation as they had interpreted it. Now, when they got into the middle of the case, this policy suddenly changed into the all-comers policy. And that is just a general statement that you are open to all students regardless of anything. That any Hastings student has a right to be a member or a leader of any student group. This all-comers policy, I'm not surprised once some lawyers, got some serious look at Hastings' policy and its viewpoint nature, and certainly viewpoint nature as it was applied to CLS, realized that they had a big problem here. And so up pops in a deposition the all-comers policy. I don't think as I will explain, I don't think the all-comers policy is constitutional either. But one of the interesting questions is the court to decide this case based upon what the policy was at the time when they were refused, or are they to decide it based upon this new policy that's actually, as far as the record is concerned, never been applied to anyone? But in any event, of course, the grounds that are argued by CLS is a violation in the context of a limited public forum, the First Amendment rights of speech and association on the one hand, and the First Amendment right of free exercise of religion on the other hand. And here, we're also on pretty well-traveled ground. CLS, under the First Amendment speech and association doctrines, is what's called an expressive association. That is, it is formed for the purpose, in their case, of speech, of expressing and advocating a viewpoint about religion. And and of course, expressive associations may be political, they may be cultural, they could be all sorts of different types of organizations in terms of their message. But if they have a message, then they are considered an expressive association. And the court, in 5 cases in the U.S. Supreme Court, has explored then when can an expressive association's message be affected by at all. And there are 2 things that come out of those cases. One is that requiring people to associate with people that they don't want to associate with, or with messages that they don't want to associate with, is a violation of their First Amendment right of an expressive association. Because if they must associate with people that have a different message, or with a different message, well, that prevents the group from defining its own message. And it has that right under the expressive association doctrine to do that. Now, only when the court has found, like in the JCs or the Rotary Club, that having women members be required to join by state law did not affect the message that those organizations had defined for themselves. Did they move then to strict scrutiny and see if there were compelling governmental interests, and prevention of discrimination is often a compelling governmental interest. But the threshold was, did it affect the message of the organization? And if it did, as in Dale and Hurley, the Boy Scouts case and the Irish parade in New York, St. Patrick's Day parade, then there is no governmental interest that's sufficient to allow that sort of violation of the First Amendment. I've already said I think the first policy is obviously viewpoint. Well, number one, it obviously affects the message of the organization. I mean, after all, it is the leaders that carry out the message. In CLS's example, both members, thank you, and leaders will lead their weekly Bible study, and it's absurd to think that that their message would not be compromised by having students that don't agree with their message conducting Bible study, or inviting speakers, or speaking publicly on behalf of the organization. So it would affect their message, and I think that basically ends the analysis. Now, they also argue that this is a violation of free speech, and we've had, in the context of public forums, again, a whole series of cases that have involved discrimination in a public forum, and many, if not most of these cases, were also universities that had established public forums and provided resources to student groups, and based upon the religious orientation of groups, they were denied access to this forum, and the Supreme Court routinely has struck that down as a violation of free exercise of the religion, or if you want to look at it as an expressive association, under that line of cases as well. Now, of course, the government here asserts that there is a compelling interest that would justify the policy. And and I just don't think that's so. If the court would get to the compelling governmental interest question, I think they will find that there is no compelling governmental interest here. Now, there may be, and certainly would be, in other instances. For instance, if the state of California or Hastings Law Center said, they were not going to allow the admission of Catholics, the government would have authority to have a non-discrimination policy, and that policy, I think, meets a compelling governmental interest. Furthermore, if Hastings would adopt such a policy. Furthermore, McDonald's. The government can adopt a non-discrimination policy directed at McDonald's, and can enforce it, and would have a compelling governmental interest. But there is no compelling governmental interest to change the message of an organization, because that's what's involved here. The message, groups that are established to convey a religious or political messages, you could say, certainly here it's more, I would say, religious message, and there is no compelling governmental interest to regulate what messages people can speak. I mean, if that were to be true, they can make it a crime to advocate for some people to get together and advocate points of view on whatever subject. And in the good times, if you're committed, to, let's say, you're pro-choice, in the good times, you'll have the Obama administration that would, maybe they would outlaw the pro-life message. In the bad times, you'd have the Bush administration. Maybe they would outlaw the pro-choice message. We all have a stake in the ability of us to join together with other private citizens and be able to formulate a message and advocate that to the public without governmental regulation, and that, at the bottom line, is what this case is all about.
Thank you so much. Aisha.
Thank you to ACS for having this event and for inviting me to present the perspective that Hastings has in this case. And I want to start by telling you what this case is not about. And Jim's litany of examples at the end of his presentation to me characterizes the distortion that I think CLS has brought before the court. And it does that by claiming they're being forced to admit people who disagree with their views. No one is being forced to do anything here. CLS's brief, many of its amicus briefs in support of CLS use the words like forced, required, compelled. Mr. Bopp's brief has one of those words 60 times.
Only?
Only. Really, this is like me telling my kids, you get your allowance if you do your chores. That's a real choice. And I'll tell you, my daughter wants her allowance and my son doesn't. His room's a mess, hers is pristine. It's also not about whether CLS survives or perishes. We're talking about a few $100s a year. We're talking about access to bulletin boards, advertising in a weekly official newsletter, posting things on a bulletin board. They can still access email. They can still access Facebook. And demonstrating that it's not about whether it survives or perishes is the fact that after CLS chose to forego recognition, it continued to meet, it continued to hold meetings, and its membership nearly doubled. Likewise, it can survive with the funding. It can survive accepting people who don't agree with its underlying mission. And the predecessor organization to CLS did that. For about a decade, it survived. It continued to advance its message despite living with the policy that Hastings wants to keep in place. It's also not about equal access. CLS wants a special exemption from a policy that applies to everyone else. So what is the case about? I think it's about the government's ability to allocate its funds as it wants to. And now, it's well established that the government, for example, need not fund private schools if it funds public ones. It doesn't need to subsidize abortions if it otherwise covers medical care for the poor. Now, is speech different? Can the government pick and choose among speakers that it chooses to subsidize? Again, the answer is yes. The government can choose to fund the advocacy of options other than abortion, but not to fund the advocacy or even information being provided to women about the availability of abortion. It can deny tax exemptions for all groups to lobby, but it can allow veterans groups to get that kind of a tax exemption. It can fund a whole host of artistic projects, the NEA can, but it can decline to fund Karen Finley to smear her breasts with chocolate. So, are there any limitations on the government picking and choosing among speakers? Here the answer is yes. When purely private speech is involved, the government cannot discriminate on the basis of viewpoint. And that's clear from a case called Rosenberger, is probably most illustrative of that principle, that the government there, UVA, couldn't fund a whole range of student groups at a university, but then refused to fund a group that advocated a religious perspective. So the question then boils down to, in this case, is this viewpoint discrimination or not? And that's really the main point of contention between the parties here. I don't think this policy, the anti-discrimination policy, is viewpoint discriminatory. I don't even think it's content-based. And if it's not content discriminatory, then it's plainly not viewpoint discriminatory. The test for whether a restriction is content neutral is whether it's, I'm quoting here from a Supreme Court case, justified without reference to the content of the regulated speech. Here, the non-discrimination rule applies to all groups, regardless of their perspective. They might be racist or anti-racist. They might be anti-gay rights. They might be pro-gay rights. They might be religious. They might be atheist. At most, the regulation has a disparate impact, meaning it affects some groups more dramatically than other groups. But the court, again, has said that an incidental effect on some speakers or messages, but not others, doesn't render a policy content discriminatory. So CLS then argues, well, religion is a kind of ideology, and other groups can discriminate on the basis of students' views. The environmental Sierra Club group can exclude people who want to, pillage and rape the earth. And pro-choice groups can exclude anti-choice students, but religious groups can't. Two problems with the argument. False. In this case, Hastings actually does require all groups, all ideological groups, to accept all comers. And this claim that it changed in the course of litigation just isn't borne out by the facts. There was a stipulation. That's how litigation happens. Parties stipulate to facts, and the court accepts them as true. Nobody holds a gun to people's heads to stipulate the facts, and they stipulated that all groups must accept all comers. But even if it weren't the case, and some groups could exclude on the basis of ideology, I still don't think that renders this a content discriminatory or viewpoint discriminatory policy. A pro-choice group couldn't discriminate against Catholics. It might want to, but it too is going to be subject to this anti-discrimination policy. An anti-religious group, let's say there's a group called Freedom From Religion based in Wisconsin. Let's say they had a student chapter. They couldn't discriminate against people who adhered to religious views. It doesn't even affect religious groups in the same way. Some religious groups don't want to discriminate. It might even violate their religious tenets to do so. So circling back to sort of first principles here, the parties agree that you can adopt restrictions on funding speech when the restriction is viewpoint neutral and reasonable. So I've already discussed viewpoint neutrality and why I don't think this is a viewpoint discriminatory policy, but let me touch briefly on why it also passes the reasonableness test. First off, some of the amicus briefs cover this, so I don't have time to go into detail, but the brief filed by Americans United and the American Jewish Committee does this, as does the ACLU's brief, talks about the longstanding history of discrimination on the basis of religion and other characteristics in student clubs, in universities. That certainly provides a reasonable justification for this policy. The clubs that are recognized by Hastings identify themselves as Hastings clubs. And Hastings could legitimately want not to appear to sponsor a discriminatory club. The all-comers policy that Hastings has is even easier to defend. It makes all leadership, educational, social opportunities available to all students. It's much more administratively easy. It's much easier to enforce. They don't have to get enmeshed in the question of why a student was let in or not let in. And it promotes minority viewpoints and exposes students to a diverse array of viewpoints. So they are forced, essentially, to contend with people with whom they disagree. So that sort of covers the free speech aspect of this case, which is the claim that CLS leads with. They do also raise free association and free exercise claims, let me touch on those very briefly. Under the free association interest, the court has recognized that groups have the right to gather together to express ideas. And so if you force the Boy Scouts to admit a gay person as a leader, you have trampled on the Boy Scouts' free association rights. If you force a group to include as part of its parade a contingent that advocates a message that the parade organizers actually disagree with, that likewise violates the free association interest. And if you outright prohibit a group from meeting on campus, which was presented in a case called Healy versus James, where the university prohibited the Students for a Democratic Society from existing on campus, then you again violate the freedom of association claim. So the crux of that claim and the crux of all those cases is about the government forcing an expressive group to change its message or stamping it out of existence. And here, of course, as I started with laying out for you, CLS isn't being forced to do anything. And with respect to the free exercise claim, generally applicable laws, meaning laws that apply to everyone without exception, do not violate the free exercise clause, even if they have a disparate impact, meaning even if they negatively and disparately, differently affect some group. So, for example, a prohibition on peyote use is going to impact quite substantially some Native American groups negatively. Nonetheless, because they're generally applicable, neutrally applied, they don't violate the free exercise clause. In contrast to that, if the government does something to target a specific religious perspective. So there was a case where an ordinance targeted the kind of animal killing that members of the Santeria religion undertake. That was found to be a free exercise violation because that particular religious practice was targeted. Here, again, Hastings hasn't targeted religious groups. All groups have to live under this regime if they want access to the the government subsidy and resources. One final point. The policy here doesn't just cover religion, which we focused a lot on here, but it also covers race and gender and a variety of other categories that Mr. Bopp read to you. CLS sort of throws a bone and says, well, you know, we'll let race and gender go under the radar. We'll say this part of the policy is okay, but they never say why. It seems to me that an Orthodox Muslim law students group might want to exclude women who don't cover themselves. A legal group that advocates immigration reform and thinks that, you know, since we opened the southern border, all hell has broken loose, and they might want to exclude Hispanics. A white supremacist legal group that advocates repeal of Brown versus Board of Ed might want to exclude blacks. A Black Law Students Association might decide that black power is best accomplished by excluding whites and other races. In all of those instances, the exclusion is part of their ideology. And that's the main reason that CLS has given for why they ought to be able to get the public money and continue to discriminate. And each of these groups' messages would be affected in a similarly negative way. And I think it's difficult to cabin the ruling to religion alone in any principled way. Another aspect, another category that the policy covers is, of course, sexual orientation. And there are lots of groups out there fighting against gay rights. And those groups would be allowed to exclude gay people and to demand a public subsidy for their work if CLS prevails. So to explore that issue further, I'll turn it over to Clifford.
Thank you for helping me with the segue there. Yes, Cliff. Thank you, Asha.
Thank you, and good afternoon. I'm going to talk about 3 points. First, the fact that as the case comes to the court, it is an all-comers policy. Second, the fact that CLS, as part of its case, argues that, in fact, it doesn't discriminate on the basis of sexual orientation. It's focusing instead on conduct or the conjunction of belief and conduct, and we heard that a bit in the opening comments, and why I submit that that's an untenable position. And third, that the case is about an entitlement to government benefits. It's not about a prohibition. Now, the first and third points, Aisha has just talked about, and I'm just going to touch on those briefly, but let me just say a word about those and spend a little more time on the second one. The first point about it being an all-comers policy. You know, there's a very interesting dispute in the briefs about this as it comes to the court and the way you've heard it talked about. But as Aisha pointed out, the fact is there is a stipulation to that effect in the record, and what's more, the 2 federal courts that have addressed this case, that have heard it and ruled on it, relied on that stipulation, that that's the policy. And it seems a bit unusual for the party now to be fighting that, but it's fighting it very vigorously and claiming that the all-comers policy is pretextual and that it should be looked on askance. It came up in discovery and that kind of thing. It's a stipulation. It's in black and white. 2 lower courts ruled on it. Now, why is it at issue? I mean, it's not just because people are enjoying sort of fighting over a legal technicality about the force of a stipulation. And the reason is because an all-comers policy that requires registered student organizations to admit any student at the law school seems to be one of general applicability. It applies to all groups. It applies to all students. So this sense that CLS is somehow being unfairly singled out and it's because of its religious beliefs or something like that, is completely belied by a policy that requires it across the board for all organizations and all students. And that's why it's at issue in the court. And I submit that's why CLS is trying very hard to get out from under that stipulation and the point that the lower courts relied on. The second point, CLS says, we're not discriminating on the basis of sexual orientation. We're focusing on conduct and on the conjunction of belief and conduct. Now, and by the way, unrepentant homosexual conduct is explicitly a prohibited basis for membership by CLS. Melissa didn't mention that explicitly when she was going through it, but it is explicitly stated. It's not just something that you can infer from their other definitions. Unrepentant homosexual conduct is explicitly a prohibition. And we submit that to say that that is not discrimination on the basis of sexual orientation simply cannot be credited. That this is a situation where conduct and orientation are inextricably intertwined. It's what sexual orientation means in this context. And there are many other examples that one can give. You take in the religious context. If somebody said, well, we're banning yarmulkes, but that's not discrimination against Jews because it's just a practice. We're banning praying to Mecca 5 times a day, but that's not discrimination on the basis of religion. We're banning anybody who takes communion, but that's conduct. That's not belief. It would be untenable if somebody said, we're banning wheelchairs and guide dogs, but that's not discrimination against the handicapped. That's just banning conduct. The distinction simply doesn't hold up. And there are numerous other areas of the law that recognize in a wide variety of contexts where conduct is integral to a definition of the group that's being affected. And in fact, the Supreme Court itself, in various cases dealing with sexual orientation, has had that recognition. In Lawrence versus Texas, when the Supreme Court struck down the ban on sodomy, that was conduct. And it was related to, and very specifically in Justice Kennedy's opinion, to the personal nature of what was at stake. In Romer versus Evans, which struck down an enactment from the state of Colorado that related to sexual orientation, conduct and acts were one of the definitions. So the Supreme Court previously has had that recognition in this context. And, by the way, speaking of before the litigation, the CLS in the past frequently has said that sexual orientation is a basis for disqualification. And there are a number of statements and policies by CLS. So the claim that it's not discrimination on the basis of sexual orientation, I think, is untenable. Now, a couple of additional justifications for that position from CLS. First, CLS says, well, it's not just even about conduct. It's about unrepentant conduct. So if somebody's repentant, we would allow them. So it's not really about conduct. Now, once again, and you think about this in other contexts, saying whatever else you want to say about that, saying that that's not discriminating on the basis of sexual orientation is simply not tenable. It would be like saying if a white supremacist group said, we'll admit blacks as long as they admit they're inferior. Or if a male group said, we'll admit women as long as they admit they're inferior, their places in the home. Obviously, that's discrimination on the basis of race or gender. When you make a condition of membership for a group that it admits its inferiority, that he or she is repentant about who he or she is, that is discrimination on the basis of orientation, on the basis of status. And a similar argument in defense of the proposition that it's not discrimination on the basis of sexual orientation is the argument that, well, again, maybe it doesn't exclude all gays because they could be repentant, or it doesn't exclude, it excludes some heterosexuals because of adultery and other things like that. And it is well established in the Supreme Court cases in a wide variety of contexts that if you have a discrimination against a group, the fact that you can point to some members of the group who are not excluded doesn't save the discrimination, or the fact that you can point to members of another group who are also affected doesn't save the discrimination. Last point I just want to touch on briefly, because it is very important to emphasize and reemphasize this point, is that this is about an entitlement to benefits. Nobody is saying the Christian legal society cannot have whatever membership criteria it wants. It can condemn any lifestyle choices that it wants. But what it cannot do is claim a mandatory entitlement to a government benefit in order to give effect to that choice. And that's what this case is about. It is about an entitlement to government benefits. And you think, just to take one example, the Supreme Court repeatedly has taken a very strict view on this type of claim. There is an unconstitutional conditions line of cases. It's an exceedingly high hurdle. And you all remember, I'm sure, the Rumsfeld case about law school campuses and military recruiters that garnered a unanimous court. And whether the argument of the law schools there was that, oh no, in the fact making our entitlement to federal funds be contingent on having this person come, that's unconstitutional. And the court unanimously rejected it. It says, you have a choice. You can do whatever you want. Take the funds and have the military recruiters come, or don't take the funds. It's your choice. And it's exactly the same situation here. And if the court were to accept CLS's claim of a mandatory entitlement, we submit that it would work a fundamental change in the court's law on entitlement to government benefits.
Thank you very much, Cliff. Holly, yes.
Thank you so much. Let me add my thanks to ACS and to Melissa for your work in putting this panel together. It's a delight to be with my colleagues and friends and to see so many folks here that I have worked with and learned from through the years. So thank you very much. And I'm especially impressed with my panelists' ability to take on the mantle of the parties very well. I know I read a lot of briefs in this case, and so I was a little bit confused by the different amicus standpoints, but I was very impressed by the role-playing of the intensity and the clarity of the two parties' arguments. But all of you noted probably that there are a lot of amicus briefs in this case, and part of that is because there's a lot of different ways to see these cases, to see this case and some that are similar. What I wanted to do with my time here is a couple of background points, as Melissa said, to talk about how we came to the perspective that we presented to the court, and then a couple of the brief that we filed breaks down into two main points that will explain a lot. First of all, for those of you who aren't familiar with the idea of filing an amicus brief on behalf of neither party, it doesn't mean that you're telling the court to actually say nobody wins and both teams lose. I can't really imagine them doing that, although there are times when they are urged to sort of punt to find a way out of the case. The reason that the neither party brief that we filed in this case, and we were joined by the Interfaith Alliance, we came to because what we wanted to offer in this case and what we thought was significant to offer was less about which party wins, but about how either party would win and how that case, how the decision would be structured. We want a decision that will resolve the conflict of competing goals, and I'll describe kind of how I see this case, but mindful of this very particular context without doing damage to broad religious liberty principles. The 2 points I wanted to make sort of in background are, I serve the Baptist Joint Committee for Religious Liberty that has been involved in religious freedom cases for more than 7 decades. Our sole mission is to promote religious liberty, and we do that for all, but it clearly comes out of that word Baptist, a historical experience, theological experience. I see many people who've covered this issue for a long time, and they know they're aware of where that comes from, but it's a position that is grounded in protecting both no establishment and free exercise rules out of a goodness for religion, religious liberty. consistent with that focus, as we evaluated this case and some of the cases in the lower courts that dealt with similar issue, we were very concerned that the big picture was going to get lost. We felt, first of all, that we wanted to do something that would recognize that religious freedom is protected not just by those two clauses that most of the cases are decided on, no establishment or free exercise, the first 16 words of the Bill of Rights, the freedom of religion clauses, but also demands that we have good protection for religion in freedom of speech, freedom of association, and what is known as the church autonomy doctrine, sort of autonomy, self-definition of groups, and there's some amicus briefs that deal with that, which is a constitutional doctrine that doesn't fit squarely within one of the two religion clauses. So we wanted to do something in this high-profile case that would remind people that if you care about religious freedom, you got to look at the big picture, the broad picture. So while free exercise and non-establishment are not the primary issues, these other concepts are more prominent in this case. That doesn't mean this doesn't have significant religious freedom implications. I want to say, too, that I think, while I do not think, and I probably could get some agreement from our panelists here, I know I could some, that I cannot say that it is widely understood how America protects religious freedom. I will say that it is widely a point of pride, that America prides itself on having strong commitment to religious freedom, and that it is a point of pride admired by those living here and abroad, and not that we don't fight about it or have to struggle for every group that comes along, but that we want to protect it. And so again, that's the kind of broader perspective that we wanted to bring to the case. In some ways, this case is like a lot of other religious liberty cases. It's not about the definition, how far does no establishment or free exercise go, but I see it as a conflict of rights. So you've got this very important religious freedom issue that we all care about, at least generally, that we want America to care about religious freedom. And I work for an organization that's our dominant, controlling interest. So I'm coming to it from that perspective. That doesn't mean that there aren't very important other values, societal values, legally protected values, other sometimes constitutional values, with which it will clash. And so the real question is, how do you decide this sort of clash of conflicts in a specific context? And that's what we try to do here. That was my long one-point introduction. The second one is I have to note there is a little bit of irony in that the Baptist Joint Committee is formed and committed to religious freedom because part of the Baptist historical story is that we were forged in the fires of persecution based upon the coercive nature of a state religious creed. So we're not real fond of enforcing religion through signed faith statements, and there have been a lot of fights in Baptist life about that. But while we all share, I'll say broadly share this value of religious freedom, I think I would like to get some agreement that it is value, a high value, but it is not content specific. So that standing up for religious freedom should not depend on the actual content of the religious group that is asserting their religious freedom. And that's why when you do what I do, and many of us, you find yourselves sometimes, working for a group or with a group consistent or inconsistent with some of your beliefs. Anyway, now to get on to the actual brief here. There are two things that we did. First of all, looking at this case and assessing what is the context. If the conflict that we saw was really this religious freedom interest of association and freedom of association and speech that we do see in an equal access context, and to decide their own membership for CLS to say, to be a member, you have to sign this faith statement with all that it carries with it, our interpretation, not only belief in the Scripture, but our interpretation of certain Scripture. That is a autonomous right, and in this context of a broad forum that Hastings has created, that is a very significant interest, and we saw that as something that was a primary kind of religious freedom interest. Equal access, to us, we throw that word around a lot, but I'm not sure we always are talking about the same thing. But for us, equal access in this case is the idea that the school created a broad forum for private speakers, student groups, to promote their own message, to gather according to common beliefs as a means of social networking, entertainment, happy non-law school time, you know. And as you see, there's 60 clubs, and they emphasize everything from legal perspectives to religion to wine to ultimate frisbee. So this kind of forum is usually created in a way that is very careful not to create any kind of sponsorship between the school and the individual groups. The BJC has long supported this kind of equal access forum as something that is a positive good for religious freedom. It allows religious groups to participate in ways that are kind of normal like society, like in a public way, without the danger of the no establishment problems that we are very concerned with, without raising the specter that the school is actually advancing a particular religious perspective or religion in general. So those forums we think are good for religion. We want to see them operate, and part of that operation is allowing them the right to define themselves. So our analysis of the case has, the brief that we filed, talks about that, the background of this equal access principles, the fact that there's a federal law that applies in high schools, high schools where there's a higher concern for no establishment clause values because of the kind of more coercive nature maybe of a high school environment and the tender age of the kids there. There is this federal statute about equal access that allows groups to define themselves, but with a distance from the government to make sure there's no sponsoring of religion. So on the one hand, our brief is focused on seeing this as an equal access case with that history involved and how that can support religious freedom by allowing, even in controversial cases, even where it's difficult for a campus, to allow groups to define themselves. And so we kind of saw that, wow, Hastings did the good thing. They opened the forum, have lots of diversity. They got 60 cases. But then they did a not so great thing that said, but we're going to apply this policy that says everybody comes, So you can't really protect who you are, what you are, because you have to let in your opposite. Maybe you're people who want to destroy your message and basically obliterate the forum. So that part of the brief also points out that there is this whole line of cases about freedom of autonomy, church autonomy, and many other briefs. Some other briefs did this well to talk about that was something the court should be mindful of, a right for religious groups to define themselves. The second thing is probably more important as far as what would distinguish our brief is, and that is that it sounds like people might say, well, it sounds, Holly, like you're leaning towards CLS. Well, in some ways, we are on the autonomy argument, but does that mean they have this right to funding? And I heard my colleagues here say, there's not a right to this entitlement. Not only is there not a right to this entitlement, the fact that there's the kind of money involved raises separate Establishment Clause concerns that are not directly at issue in this litigation, but that all people who are concerned about religious freedom and the no establishment principles of money going to religious groups have to be aware of, and I'm not saying that others are not, but it raises red flags. It raises red flags, and that was something we were very concerned with. So they said, so we didn't go with CLS because you don't want them to get the money. You could say that, but why aren't you on Hastings' side? Why would we reward the group who set up the policy that bundled the money with the forum? It doesn't lead us to the other side. So that put us in this position of neither party. Yes, there's a case, Rosenberger, that allowed some money to go to private speakers in a forum basis, but this case is distinguishable from that. It goes beyond that. Undesignated money, direct to students, to a religious group, a Christian Legal Society, whose purpose is for the fellowship and nurturing of Christian lawyers, encouraging Christian discipleship, and all of these things that's basically a religious purpose for religious activity. So that was another concern that we wanted to put before the court, that if it decided, wanted to make sure that it was decided, or ask the court to decide in a way that does not unnecessarily expand, do damage to the no aid principle, which is also fundamental to protecting religious freedom.
Thank you so much, Holly, and thank you to all the panelists for those great remarks. I know we want to react to one another a bit, but because we have so many members of the press here and we want to get to your questions quickly, I want to go ahead and cut to that, and we will shoehorn in our comments to one another in our comments to responses to the questions. So particularly if the members of the press, I want to make sure I get you in. I want to recognize you right away. So if you could lift your hand and let me know. Pete Williams?
Thank you.
Yes.
Could I ask Mr. Bopp? Oh, thank you very much. If I could ask Mr. Bopp and Mr. Sloan about something that's in the Hastings brief, and you both talked about it a little bit. They say that La Raza has a bylaw that restricts policy membership only to students of La Raza background, that is to say, people of Latino or Mexican descent. If that is correct, and the university tolerates that, then what's the legal distinction between that, allowing that, but not allowing CLS to do what would appear to be something similar?
Well, I think the first point about that is that it demonstrates that they don't really have an all-comers policy. In fact, not only La Raza, but most of the groups that are political or cultural or religious or racial in character have those requirements, type of requirements. You have to be a Democrat to be join the Democrat club. So there is really no such thing as an all-comers policy at Hastings. The only one that has been denied is CLS, and that was based upon religion and their position on homosexual sex. So, but secondly, you're asking, why does Hastings tolerate that?
I'm asking what is the legal distinction?
Well,
what's the legal distinction that Hastings asserts that permits La Raza to make that distinction, but not CLS?
they've never made one that I know of.
Well, there is at least one very important distinction, which is that La Raza agreed to follow the university's non-discrimination policy. CLS is the only one, the only organization that has ever said, we won't follow it. And so that teed up the issue. All the other registered student organizations have agreed to follow the policy.
Well, but they don't follow the policy.
Well, that's
all you have to do is read their bylaws, which is the way they found out, the university found out that CLS was not going to follow the policy because of their bylaws require the statement of faith. And so all you have to do is read La Raza's bylaws. That is, if you were serious about enforcing this policy, which they obviously are not, and you would find that they discriminate on the basis of race or national origin.
Jim, could you comment on the joint stipulation that both Aisha and Cliff mentioned in the briefs, just in terms of answering that notation that they made?
I don't know either the history or the context of the joint stipulation, so in terms of this particular provision, so I don't feel like I could answer that.
Okay, that is addressed in CLS's reply brief in some length if you're interested in that. But let's see, other members of the press, we want to make sure that we get to you. And please wait for the microphone and say, if you wouldn't mind, say your name and the organization you're representing, that'd be great.
I'm Mike McGough from the Los Angeles Times editorial page. I had a question for both Aisha Khan and Cliff Sloan about the no-comers policy, not about whether and when it appeared in the litigation. But is it totally at war? Is the idea of an all-comers policy at all compatible with the idea of whether you give money or not, promoting some sort of public forum in which affinity groups argue with one another for the attentions of the students? In other words, if every organization is an all-comers organization, why not just have one?
Why not just have one organization? You know, I think the best answer to that is Hastings' actual experience, which is that I think students generally gravitate to organizations with which they disagree. I mean, with which they agree. And so there isn't really this factual basis to be concerned about takeovers and distortions of messages. I mean, and not just do you have to be, you don't just come into the group and all of a sudden start changing its message, right? You have to You have to actually become integral and central to its message delivery. And I just think the real world is a check on that, and that, in fact, is borne out by the evidence here. And lots of universities have these kinds of policies, and it hasn't resulted.
Wait, can I just answer your original question first? Which is that I think there's a very, very important point here, which is that the question isn't whether one thinks it's a good policy or a smart policy. The question is whether it's a permissible policy. And lots of universities and lots of public universities could permissibly decide, by the way, it's all comers, not no comers, because the idea is we invite everyone. And lots of universities could decide, no, we don't want an all-comers policy. We think, or we're not going to enforce an all-comers policy for reasons you suggest and that kind of thing. But, and Professor Eugene Volokh has written about this, and he has said, I think this is a dumb policy. He said, I don't get the point of it, but I am convinced it's a constitutionally permissible policy choice. And I think there's a very big difference.
This is just a quick follow-up for both of you, and it gets to Aisha Khan's point about in the real world, who's going to want to go to one of these groups. Anyway, doesn't that sort of prove too much from your point of view? What's the harm that we're all worried about here if, in fact, there's this self-selection and no gay and lesbian student is going to want to go to the Christian Legal Society anyway? Well,
the harm that we're worried about is the government's ability to decide what it wants to fund and not fund. That's really what the case is about, is it may turn out that all the Christians go to CLS and all the atheists go to, the American Atheist Group on campus, but the government doesn't want to be funding the groups that engage in discrimination.
No, the government wants to discriminate among who they fund. And if it's a disfavored group, they want the government to have the authority to say, we're not going to fund any organization that opposes homosexual rights. We're not going to fund any organization that has a religious message. And we're a long way down the road where whether you call this benefits or what you call it, once the government has established it, you can't discriminate. This is an engine for discrimination that they're advocating, and discrimination by the government. And they are going after, at most, private discrimination as a justification for it.
Just say one thing about that. First of all, what Jim just said about we don't want this group or we don't want that group is not what your question was, which was an all-comers policy. And on the all-comers policy, the reason that Hastings has given is that their view, and again, one can agree or disagree with this as a policy choice, but their view is we have a law school community, and it's very important to us that any member of our community, if you're going to be a registered student organization, you're open to all members of our community. That's just a very basic, simple, inclusive principle that we think is important to the kind of community we want to foster.
And Jim really grossly overspeaks, sorry, sir, but to say that that Hastings is saying religious groups can't exist. CLS's predecessor organization existed for a decade before this litigation arose. And so
they have no access to the forum. And particularly, it's really interesting that you all used the word, thought it was important that this was a benefit. I mean, 30 or 40 years ago, the Supreme Court rejected the idea of distinguishing between benefits and rights. It is whenever the government acts, the government puts a bulletin board on the wall, says, employees, you can post your messages on the wall. They said who can do it and what the purpose of the forum is. If the government said then came in and said, well, no Christian, you can't post that. That has religious message, or you can't post that. That is opposing gay rights. That would violate the First Amendment to the Constitution. And you can look at that bulletin board if you want to as, oh, it's a benefit. I mean, it's there. Somebody bought the bulletin board. And it is. I mean, I would say it's a benefit, at least to a certain extent, and a cheap one. But once that's done, and the government can't offer a welfare program, and so say no Catholics can apply, or no You know, I mean, they can't do that. And so it doesn't matter whether you call it it's a government benefit or not. If they define who is entitled to it, then they can't discriminate. This is an engine of discrimination by the government. In order, I think that's the bottom line, in order to get at what they view as private discrimination. And I want everyone here.
Sorry. Oh my goodness. I'm so sorry.
That was the only way Melissa could.
That was
That's
a
the
bad
only
move.
way to cool me off.
But we do want to move to a question.
Well, let me
just a
finish this
minute.
way.
Okay.
One point. I am old enough to remember the Students for a Democratic Society and the discrimination that was against the left wing in this country. And they were driven off campus. They were denied rights to access. They couldn't rent rooms or have access to rooms on university campuses. Well, in those unhappy days, you know, it seemed like the right wing was on top. Of course, well, now here we are with the left wing on top in universities, and of course now imposing discriminatory policies against what are conservative viewpoints. And so, look, we all have a stake in this. Every one of us. It doesn't matter. And I know, you know, we have homosexual rights groups here because they think it advances their agenda, but this is about the First Amendment, not about that. This is about what rights each of us have as citizens, day after day, year after year, decades from now. Whether or not our children will suffer discrimination by the government based upon viewpoint or not.
Let me just respond to that, Jim. Okay. I'm here the same reason you are, having an argument about what the Constitution means and what it requires. And for you to suggest that there's anything else at play, I fully respect your position and your motives in being here. And I think I'm entitled, and my clients are entitled to the same respect.
Thank you. I want to collect a couple of questions and then have the panel respond to them. So over here, I see 3 hands. If you could identify yourself and your organization. So we'll collect them 1, 2, 3, and then let the panel respond.
I'm Rob Marouche from Associated Baptist Press, and this is for Mr. Bopp as well. What this line of argumentation involving specifically the funding aspect of this and other similar kinds of funding arguments that we've seen from a lot of conservative organizations in recent years is essentially arguing we have a right to government money. And it occurs to me this isn't a particularly conservative kind of argument to make. So I wonder what your response to that point is.
Oh, we're going to collect 3. Okay. 3 questions.
Hi,
and
Adele
then-
Banks, Religion News Service. I was just wondering, beyond the Rosenberger case, how unique it is for the Supreme Court to be dealing with religion and universities, this kind of intersection of those two things.
Okay, thank you.
This is Ariane with ABC. Can you talk, or can someone address how broad the decision could be? Would this affect public high schools, public colleges? Draw the line as far as how broad this could get.
Right, great. Okay, we're going to let people bite on any of those 3 that you'd like to.
Can I answer the
and
one
you can
directed
answer
at
the one
mine?
directed to you, yes.
I'll answer that one.
And I won't throw water on you this
That's
time.
all right. That's all right. No problem. In terms of access to government funding, there is 2 lines of cases, and this is the distinction. If we're talking about funding speech activity, if it is government speech, then government can discriminate based upon the message that is being conveyed. The government, if it's government speech, and of course we had the recent Summons case, where she was arguing on the other side that so we both had amicus briefs in that, reaffirmed that line, and that is that they deemed the court using the criteria that they use for determining whether or not the government has adopted the message of the monument that was placed in the park. They said it had. That made it government speech. The government can discriminate on message, on that. But if it's not government speech, if it's a forum, in other words, that's what she was arguing, it was a forum for the public to come in and set up whatever monuments they wanted to set up, so that the government wasn't adopting as its speech any of the monuments. It was private speech. Well, then you can't discriminate based upon the message. they're discriminating here based upon the message in their funding. And this is not government speech. I mean, surely everyone agrees that none of these 60 student organizations are conveying the government's message. So it's private speech, and the government can't discriminate based upon message.
Let me welcome any of the other three panelists to comment on the other questions, which were how unusual is it for the Supreme Court to deal with issues of religion at the higher university level and at the higher education, meaning the university level, and how broad a ruling do you expect? And particularly to Aisha and Cliff, do you accept the kind of way that Jim has just cabined off this case from potential other broader ramifications? Cliff's comment make me think that he might not, but I'd like to shoehorn that into that last question.
I can think of, off the top of my head, several cases that the Supreme Court has decided that involve the intersection of religion and government. They're each too complex to describe, but Southworth is one, Healy versus James, which is the Students for Democratic Society case we discussed earlier, Locke v. Davey is another one. Widmar is another one which does get some play in some of the briefing, so I'll leave it at that. In terms of the impact on other areas of the law, I think that's a really interesting question. Of course, you know, nobody has a crystal ball. It really depends how broadly the court writes. The notion of what is and isn't viewpoint discrimination has a lot of legs, potentially. And whether the court cabins its rationale to the public forum context, the free speech public forum context potentially in the university setting, which it has characterized as particularly emblematic of the marketplace of ideas, that would narrow its reach and not have an impact on, for example, social service funding, which Melissa mentioned in her opening remarks, where lots of groups are seeking access to public dollars and wanting to discriminate in hiring with that money. So I anticipate a fairly narrow ruling in that respect, but I am concerned about what viewpoint discrimination might or might not mean. We've seen that notion really expand, mushroom in the last many, many years. It's really sort of...
What about, I think the questioner was interested in particular about what application you might expect of a decision in this case in terms of its impact on public high schools or public middle schools. If you want to comment on that, that might also be helpful.
Well, let me say, and first of all, of course, I agree. It depends what the court does and how it writes it. But I think potentially, in terms of the entitlement to government benefits, I think that potentially, if the court finds that there is an entitlement here, there is the possibility of a very dramatic change in the way that the court has approached that question in the past. And I think it could have lots of ramifications. I think it could have ramifications in the high school context. I think it could have ramifications outside this particular context of religious questions. I think it would really work a sea change in the court's jurisprudence if it were to find an entitlement here.
I want to say one thing about that. I don't know how this case will directly apply to public high schools, but it will be an interesting, maybe another irony, that the Federal Equal Access Act may indeed have more protection for religious groups applying in the public high school arena than Christian Legal Society would have at Hastings Law School, as far as being able to choose its own leadership. There are equal access in public high school cases that have allowed religious groups to discriminate based upon religion. I say that because, I mean, the meaning of discrimination in that context is to define themselves and its membership according to shared beliefs. And in those cases, sometimes they make a distinction between leadership and membership that is not, was not part of the Hastings policy.
Right. Let me just grab a couple other questions. I see one hand back here. Anybody else want to sneak one in? Okay, let's get these two, or these three. Let's collect them as well before we close out here.
Hi, thanks very much for coming. I'm Cynthia Butler, just a lawyer, blogger. And hi, nice
Hello.
to see you, Melissa.
Nice to see you.
Aren't you really begging the question in sort of a circular fashion as to what is a religion for establishment purpose reasons and analysis? And will the court be addressing you on, or I guess you guys aren't arguing, but will it address anybody on what are you calling a religion? Because the notion that the whole sort of moral construct around, you might call it secular humanist, but that's not accurate because there's some Christians that are pro-gay and there's some Jewish people that are pro-gay and there's some that aren't, okay? So the notion, however, that, I'm the center of my moral universe and whatever I feel like I am without reference to any other, predetermined moral construct is it's my right to be, that is sort of a religious notion, isn't it? So aren't you talking about competing religions making competing religious claims for government money? And aren't you really, for establishment purposes, begging the question by saying that you should have, you're asking California to say through their university something that's contrary to what their law already says with respect to marriage, right? Because the current law in California is that gay marriage is not legal, and so do you expect the court to be addressing the issue of the secular humanists, the gay rights people, being able to discriminate, as this gentleman said, against somebody who holds a competing religious view? These are competing religious views, right?
Okay, thank you. And let's sneak these last two in real quick. David Lockman and...
Hi, David Lockman, personal capacity today. If I could just probe the question of government benefit a little bit, and especially to follow up on what Holly said. Suppose we unhitch this case for a moment from the money received by the organization from the university and recast the policy as you have to be an officially recognized organization in order to gain access to university rooms. If each member of the panel could address that.
So you're saying take away the funding aspect?
Yeah, take away the funding,
right.
but only recognized registered organizations have access to university rooms, other university facilities. Wondering how each member of the panel would view it under those circumstances.
Thank you. And you, sir?
Victor Stone. My question actually goes just a drop further than the last one. I guess I don't understand exactly why this is not a prior restraint by the university system. We're hearing an awful lot of wild hypotheticals, both from the panel and the audience, and I can think of even wilder ones. And I'm inclined to think the Supreme Court's going to really be unimpressed by that and say, unrepentant actors are the only ones who can't hold office. Well, don't they have to at least fund these organizations till one comes forward that's denied a position, a student comes forward who's actually, we know what he is, and we know that he's been denied a position as a leader in the organization. Without a real student, where the hypotheticals go from students who might be repentant and they're allowed to join, or who might be hypocrites trying to disestablish an organization, or, and then at the next moment we say, but wait, none of those students would even try and join the organization. So if the university is really intending to present a place for students to meet, and it's supposed to be an open society, don't they have to wait until at least one student's been denied that right?
Okay, let me invite the panelists to bite on any of those three questions.
I don't think I can address the first one because I'm not really sure, other than to say, yes, I agree that every different religious group, whether you call them religious or not, they are, yes, discriminating like La Raza to the extent that they have their shared values for organizing. So I'm sorry, I don't think I can help any more on that. David Lockman, I hope I made it clear. If the money weren't there, then obviously the association, the free speech, the freedom of religion issues become even more clear, and to me even stronger, that the university should treat all organizations the same and cannot interfere in their autonomous right to define themselves according to their beliefs. And that's, the earlier cases, Widmar and all, they say, when you have this forum, the Establishment Clause does not bar allowing everyone to participate, even religious groups to participate in an open forum like that. So I would like a Hastings policy that did not involve the money.
Let me ask Cliff or Aisha, go ahead. Yeah.
Well, I was actually just going to comment on the last question, which is that, I think what you're raising is actually a ripeness question, not really a prior restraint question. And I do think that, the case is ripe. I mean, there's, the issue is joined over this question of whether they can legitimately be a registered student organization. So I don't think that they have to kind of wait for the next shoe to drop in terms of kind of, identifying an individual. So I think it's ripe, and I don't think it is a prior restraint.
And I'll address your question about funding. If you took out the funding and just had meeting rooms, I don't see that as having any legal significance. The university has decided to provide a bundle of benefits, and all of them involve spending their money. I mean, the rooms, they're not renting them to them, they're giving them to them for free, so in terms of their use of the room. So that involves expenditures of funds of the university. So, I don't see that. It's really a pertinent distinction. The court has not drawn a pertinent distinction, and it's not a matter of entitlement to funding. It is the university has offered the funding to all student groups that qualify, and then the question is, can they in their qualifications impose discriminatory criteria based on speech, religion, and that's the issue.
And let me say, because I think I want to be clear. It's not that I would like the policy. Then the policy is still going to still telling groups they have to have all members. It's that it uncomplicates. It makes the case less complicated with this. If you took the funding aspect, what I saw in a lot of the amicus briefs and in some of the parties' arguments is that the funding aspect was being used to justify interference with the religious autonomy of the group and all of the groups.
And with that, we will pass along the case to the Supreme Court for them to tangle with it. I want to again thank the American Constitution Society and its leadership for this event and their sponsorship of it. And I ask that you join me in a round of applause for our terrific panelists.